The ultimate outcome from a stunt driving charge is not to have a stunt driving charge. And this can happen by fighting your stunt driving charge in the Ontario courts, either by A, discussing your case with the prosecutor, or B, fighting the charge at trial. But either way, you only get one chance to make your case, which will determine you losing your license for a year or more, or being able to continue to drive. So before you do either prosecutor or trial, you need to understand your evidence. The evidence in your case, called disclosure, is a combination of the roadside notes, the officer information, your driving record, and more. This is the ultimate piece of information that the prosecutor will use to determine if your case should proceed or if there's a major error that would cause the case to get withdrawn. The details in the evidence are key. So for example, the time of day of the incident, the radar reading, if the stunt charge is related obviously to speed, the officer interaction with you, the location, the car, other details. Understanding this document is really important because even if there isn't a major error to get the charge withdrawn, perhaps there is a relative minor error that can help the discussion with the prosecutor. Knowing how to capitalize on the evidence and use it in your case is critical. Emotional and personal feelings about the charge are not relevant because remember, this is a prosecutor acting on behalf of the province in a court of law. Discussing details outside of the actual evidence, it may not be relevant and it may actually work against you in your case. So understanding the negotiation process with the prosecutor is key here because they have a lot of power. They determine the penalties in your case, or they have to agree to lower or amend your charge. So one chance is really all you're going to get to fight your stunt driving charge in the Ontario court. So courts are very, very busy and prosecutors have a massive caseload. So you remember, your case is just 1 in 100 that they are dealing with at the same time. So if your discussion doesn't go well, you will most likely not get another chance to talk about your case. Provincial prosecutors in Ontario generally give you one opportunity to discuss the details of the case. So if you don't handle this discussion well, or things get heated, or you do not make a convincing case, this could be the difference between driving or not driving for a year or more. A trial is even riskier. At least the discussion with the prosecutors are private and take place outside of the courtroom. At a trial, you have to dispute the evidence and try to prove your innocence, even though the radar says otherwise. So I don't need to tell you how much skill this takes to master in a courtroom. If you choose the option of a trial and it doesn't go your way, you will lose and you will be convicted of stunt with a minimum of 1 to 3 year license suspension, $2,000 to $10,000 in fines, 6 demerit points, possible jail, and more. So now what? I'm nervous about the next steps with my stunt driving charges. So getting your car out of the impound, the high fees, all of that is just the start of the legal process. Those were only the immediate roadside penalties for stunt driving. Now you face even worse penalties in court, including that 1 to 3 year license suspension. So I always recommend get legal advice. It's free, but it can help develop a strategy to remove those harsh penalties of a stunt driving charge.